Sadly, the president was surrounded by a group of crackpot lawyers that kept telling him what his itching ears wanted to hear. And while I made my case to him of what I understood my oath of the Constitution to require, the president ultimately continued to demand that I choose him over the Constitution.
Those are some of the toughest words we've heard from Donald Trump's former vice president, likely star witness for the prosecution in his upcoming trial, which raises an interesting question when you consider the conditions of Donald Trump's release today, which Trump signed after being warned by the judge that he could be imprisoned. He violates federal or state law, does not appear in court as required, does not sign an appearance bond, or if he communicates about the facts of the case with anyone Trump knows to be a witness except through counsel or in presence of counsel. Can't communicate with any witness? There's a Republican primary debate coming up in 2 weeks, and while Mike Pence is not yet officially qualified for the debate and Trump may not appear, does that mean they can't discuss the case in the debate? Or maybe they just need to make sure one of Trump's lawyers are in the audience so it's in the presence of counsel? Back with us, Mailman, former associate White House counsel, former federal prosecutor Robert Ray, and former U.S. attorney David Kelley. David, what's the solution here?
Well, it's certainly an unusual problem, but I think it's easily overcome because I think if Pence was going to be at the on the debate stage, they would just make an application to the judge under these extraordinary circumstances. And I think the fact that it's all public, that there's transparency here, that there's no opportunity really to influence the witness, I think the judge would just sign off on it. And as you say, Dan, putting a lawyer in the room, which undoubtedly there will be one at least, I think will solve the problem.
So, Mailman, easy solution here? I mean, it seems to me what they're trying to prevent, obviously, is witness tampering more than just influencing witnesses, as might be the case in an ordinary case.
Yeah, this problem was almost supercharged in the classified documents case because there, a lot of the expected witnesses are Trump's employees. And what's he going to do? Fire all of his employees so he can't talk to them? I think that would not be beneficial to anybody. And it turned out that the Department of Justice never actually asked for this non-contact provision. It was something that the judge put on, and this is the magistrate judge also in that case. And so it ended up being that there's not going to be a no contact now, and we'll kind of think about it and work on it once the witness list is settled.
Right.
And maybe that'll be somewhat the case here, which is, yes, this is a problem, but it's kind of a down the road problem because we just don't have a witness list yet.
It's a problem that we in the media love to make a bigger deal than it actually is. They will be able.
They would never.
No, never. No, anyway, there's easily solvable, right?
I'm fairly confident, though, that the president is not going through his lawyers to ask prior permission of a judge about what he can and can't do on the campaign trail.
On the campaign trail, maybe, but
I mean, maybe David's right. I think that's, to me, unimaginable.
So you think that he's just going to do whatever he wants?
I think if there are people on the debate stage, he's not going to a federal judge to say, is it okay if I talk to Mike Pence while I'm debating him on the debate stage? I think that's silly. I wouldn't.
You wouldn't ask?
I wouldn't be asking for permission.
So then they'll just do the other option, which is just to have one of the lawyers in the audience and just not. The lawyers will be careful.
Maybe there's a solution, and yes, the lawyers are going to be careful. They're not going to want to do anything that leads their client into a problem. But I find it hard to believe that he's asking permission.
I've got almost no time, but David Kelley, I want to ask all of you really quickly, do you expect that this trial will happen before the election? David Kelley?
No.
Nay, Mailman?
I think because there's so much discovery and pretrial litigation.
Nay?
No, I think they're going to appeal legal issues before they get to a trial. It's going to take a while.
Robert Ray?
I agree. And there's so many ways, particularly of a case of this magnitude, to gum up the works. Things like trying to recuse the judge. Discovery, make a motion for a change of venue. Even if you lose, go up on appeal. If you want to gum up the works and are determined to do that and you're the defendant, you can find ways. I don't think there's any way this case goes to trial before the election.
And I
will say this judge, I think, is determined to the contrary.
Well, maybe so. But I always remind people that when you talk about a speedy trial, as the prosecutors do, that's not the right of the prosecution. It's actually a defendant's right to a speedy trial.
Well, it's also the public's right. It's also the public's right. But
constitutionally, it's the defendant's right.
But
thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.